This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.
Imagine dropping your child off for the weekend. You pull into your ex's driveway, and you know for a fact that the person sitting on the couch inside has a violent criminal record.
Yeah, that's a nightmare scenario.
It really is. I mean, your stomach drops, right? You want to just refuse to let your kid out of the car. You want to call the police. But then, you realize the police can't actually do a single thing about it.
Right, because legally your co-parent has the right to their time sharing.
Exactly. And there was no court order saying that specific person on the couch can't be there, which is just wild to think about.
It is a profoundly terrifying moment. I mean, the immediate visceral instinct is to protect your child at all costs, right? You just want to demand that a judge instantly banish this dangerous third party from ever coming near your kid again.
Because obviously that's what any parent would want.
Right. But the legal reality, particularly when you are navigating the family court system, it just doesn't operate on instinct. It operates on evidence, jurisdiction, and some very, very strict procedures.
And that is exactly who we are talking to today. I mean, if you are listening to this deep dive, you are likely in this incredibly stressful situation right now.
Yeah, you're looking for answers.
Right. You are trying to build this fortress of safety around your child. But you've realized you only control the gates to half of that fortress. You need to protect your child from someone in your co-parent's household, and you need to know the actual rules of the game in Florida. Specifically, we're looking at Broward County and the 17th Judicial Circuit today.
Yeah, and we are going to break down this entire landscape. First, I mean, we really need to look at whether a family court even has the power to restrict a third party.
Which is a huge question.
Exactly. Then we are going to walk through the exact evidentiary standard, like what actually moves the needle for a judge. We also need to highlight a massive procedural trap involving emergency motions that ruins cases before they even begin.
Oh, yeah, we definitely need to get into that trap.
For sure. And finally, we'll look at how you actually go about modifying a parenting plan, especially given a recent, pretty major change in Florida law.
Okay, well, let's start with the most baffling part of this whole thing.
Yeah.
You're telling me that if a parent goes to a family court judge and says, hey, my ex's new partner is a violent felon, ban them from seeing my kid, the judge can't just do that.
No, they really can't.
But how? I mean, how can a family court claim to protect children if it doesn't have the power to just banish a clear threat?
So to understand why a judge can't just issue that ban, we have to talk about procedural due process and jurisdiction. There is a crucial 2026 Fort Lauderdale appellate case that explicitly addresses this exact thing.
Okay.
Family courts, they have broad authority under Florida Statutes section 61.318 to protect the, quote, best interests of the child. But that authority only extends to the people actually involved in the lawsuit.
Which would just be the parents.
Precisely, just the parents.
Wait, because the new partner or, the sketchy roommate, they aren't actually a party to the divorce or the custody case.
Exactly. I mean, think about the fundamental rights built into our legal system. You cannot have a binding court order issued against you if you haven't been given official notice, right? If you haven't been served with papers, and if you haven't had a chance to defend yourself in front of a judge.
Right, that makes sense.
The court cannot issue an order against a ghost in the courtroom. It completely violates fundamental due process.
So it's almost like, okay, think about it like this. If I own an apartment building, right, and I rent a unit to a tenant.
Okay, I like where this is going.
And the tenant moves their awful friend in. I can't just evict the friend because they aren't on the lease. I don't have a contract with them. I have to go to my tenant and say, hey, get rid of this person or you are getting evicted. Is that kind of what the court is doing?
That is a brilliant way to visualize it. Yes, exactly. The court cannot touch the roommate, but the court absolutely holds the lease, so to speak, with the co-parent.
Oh, wow. Okay.
So the judge turns to your co-parent and issues an order restricting their behavior. The order basically says, you have the right to your time sharing, but you are strictly prohibited from exercising that right while this specific individual is present.
Right. So the burden is on the parent.
Exactly. The order tells them, if you allow them around the child, you, the parent, are in contempt of court. So the restriction is placed entirely on the parent's exercise of their own custody rights.
Okay, that makes sense mechanically. But how do these restrictions usually even get into a parenting plan? Because, I hear about things like morality clauses or rules where, say, you have to date someone for a year before introducing them to the kids.
Right. People talk about those a lot.
Does a judge just stamp those onto every case just to be safe?
No. And that is a massive misconception. A judge rarely, almost never, invents those kinds of sweeping restrictions on their own initiative. Yeah. When you see a parenting plan with an overnight paramour restriction, which just means no romantic guests can sleep over when the kids are there, it's almost always because the parents sat down in mediation and voluntarily agreed to it.
Oh, so they chose to put it in there.
Exactly. The court just approves their contract. If you just walk into a courtroom out of the blue and ask a judge to impose like a 6-month waiting period for new partners just because you prefer it, the judge will almost certainly deny it.
Because it borders on the court kind of micromanaging a parent's personal life without a really justified reason.
Precisely. The court defaults to trusting parents to make their own household decisions, unless you can prove that trust is fundamentally endangering the child.
Which brings us to the most critical part, right? The proof.
Oh, yes. The evidence.
Because my ex might swear up and down that their new partner is a great person who, I don't know, just made some mistakes.
Yeah.
But I know they are dangerous.
Yeah.
How do I legally prove they are a threat? Because clearly my bad vibes or my personal dislike for the person isn't going to hold up in court.
Your bad vibes will get you absolutely nowhere.
Right, I figured.
The legal standard you have to meet is called a preponderance of the evidence.
And what does that actually mean in practice, like for a normal person?
It just means more likely than not. You have to convince the judge that there is a greater than 50% probability that this third party poses a substantial risk of imminent abuse, neglect, or harm to the child.
Okay, so more than 50%.
Right. And you don't just throw evidence at the wall,
Right.
You have to attach it to the specific best interest factors listed in Florida Statute 61.13, subsection 3.
So how does that work? How do you map a bad roommate onto a legal statute?
Well, let's look at factor B, for example. This factor examines the anticipated division of parental responsibilities.
Okay, meaning what exactly?
In plain English, it means how much of the actual parenting is your co-parent delegating to this dangerous third party.
Oh.
Like, is the co-parent leaving the child alone with them? Is the third party the one doing the disciplining, the driving, the overnight supervision? If your co-parent is heavily delegating to someone who is unstable, that directly triggers factor B.
Okay, so delegation is a huge red flag. But what if they aren't delegating? Like, what if the person is just chaotic or violent on their own?
Then you look to factor M, which is critical. This is where the court evaluates any evidence of domestic violence, sexual violence, child abuse, abandonment, or neglect.
That sounds like a heavy one.
It is. And then there's factor Q, which examines the demonstrated capacity of each parent to maintain a substance-free environment.
So let's talk about the actual evidence you need to prove those factors. A judge isn't going to just take my testimony that this person is a violent drunk, right?
Testimony is evidence, but in a he said, she said scenario, it's incredibly weak.
Yeah, that makes sense.
Courts want verified third-party documentation. The absolute gold standard includes verified findings from the Department of Children and Families, DCF. They want police reports showing officers were actually called to the home for domestic disturbances. They want certified criminal records.
Okay, but what if I don't have a police report?
Mm-hmm.
What if I just have, like, my ex's own text messages admitting things got out of hand? Or maybe photos?
Oh, documented behavioral incidents are highly persuasive. If your co-parent sends you a text saying, sorry I couldn't pick up the phone, Dave was throwing things again, that is a direct admission.
Wow. Okay.
Yeah. Medical records if the child was injured, or even school records showing a sudden severe drop in the child's academic or emotional well-being, these all build the picture.
So you're building a case piece by piece.
Exactly. But there is another incredibly powerful tool the sources highlight, and that's the social investigation under Florida Statute 61.20.
I've heard of these. How does a social investigation actually work? Because, it sounds invasive.
It is very invasive, but it's often necessary. Under Section 61.20, the court appoints a qualified professional, usually like a mental health expert or a licensed investigator, to deeply examine the family dynamic.
So they don't just sit in an office and read paperwork?
No, not at all. They don't just read affidavits. They actually go into the homes. They interview you, your co-parent, the child, and critically, they interview the third parties living in the home.
Oh, wow.
They also talk to teachers, doctors, and neighbors.
That seems like it would give the judge a much, much clearer picture than, say, a 10-minute hearing.
It does. And legally, the 61.20 investigation is a total game changer because of how it handles hearsay.
What do you mean?
Well, normally in a courtroom, you can't testify about what your neighbor's cousin said they saw, right? That's hearsay and it's inadmissible.
Right. Objection, hearsay.
Exactly. But a 61.20 investigator is allowed to gather all of that hearsay, synthesize it, and include it in their final report to the judge. It allows the court to see the reality behind closed doors that formal evidentiary rules might otherwise block.
Okay, let me stop you here for a second because I need to challenge this. Let's say this third party, the new boyfriend or girlfriend, has a rap sheet a mile long. Let's say they have multiple felony convictions for assault or drug trafficking. Doesn't the court just look at that criminal record and automatically say, nope, time sharing is suspended?
You would think so, right?
Yeah. It feels like that should be an automatic red flag.
It is a massive red flag, but legally, there is no automatic rule.
Seriously?
Yeah.
A violent felony conviction doesn't automatically restrict contact.
No, and the appellate courts in Florida have been very, very explicit about this. They do not apply a bright line per se rule that a new partner's criminal history instantly equals harm to the child.
That is infuriating. I mean, why on earth wouldn't a judge automatically protect a kid from a convicted felon?
Because the court has to look at foreseeability, recency, and the concept of rehabilitation.
Okay, unpack that for me.
The mechanism here is vital to understand. Let's say the new partner had a felony drug conviction 15 years ago when they were 19. They served their time, they've been clean for over a decade, they hold a steady job, and they have a healthy dynamic with the child. If a judge automatically suspended time sharing based purely on that old piece of paper, it would be wildly unjust.
Ah, I see. So the judge is looking for a current threat.
Exactly. The evidence must be tied to a current substantial risk. And here's the massive paradigm shift for a parent to understand, really.
What's that?
The judge's ultimate focus isn't just on how bad the third party is. The focus is on whether your co-parent is failing to protect the child from a known active risk.
Oh, wow. So it comes back to the parent again.
Right. Do they know the partner is actively using drugs today? Do they know the partner had a violent outburst last week? And knowing that, are they still leaving the child in their care? It is your co-parent's present judgment that is on trial, not just the third party's past.
That is a huge realization.
Yeah.
It's about proving the co-parent is failing as a shield right now. Okay, so let's say you have the proof. You have the current text messages, you have recent police reports, and you are sitting at your kitchen table terrified because your child is supposed to go over there tonight.
Right, panic mode.
The immediate, undeniable urge is to call a lawyer, march into court, and file an emergency motion to stop the visit right this second. But our sources warn of a massive procedural trap here that destroys cases.
Oh, it is a trap that ensnares so many parents, particularly those who are trying to represent themselves in a panic. When a parent Googles family court emergency, they almost always stumble onto Florida Family Law Rule of Procedure 12.610.
Which sounds exactly like what you want, right? I mean, it governs emergency injunctions. Why is that a trap?
Because Rule 12.610 is strictly designed for injunctions for protection against domestic violence, repeat violence, dating violence, sexual violence, and stalking.
Okay, so it's a specific tool.
Yes, it is an entirely separate legal mechanism. It is not a tool for modifying a parenting plan or adding a third-party restriction to an existing custody order.
Oh, I see.
If you file a motion under 12.610 to try and fix a parenting plan issue, the judge is going to look at it, realize you used the wrong procedural vehicle, and just dismiss it outright.
And meanwhile, you've wasted precious days, you spent money, and your kid is still going over to that house.
Exactly. You are trying to use a hammer to turn a screw. If you are in Broward County and you need to stop time sharing on an emergency basis, you have to follow the 17th Judicial Circuit specific rules, which are laid out in Administrative Order 2019-9 UFC.
And what does that order actually require? Because I imagine asking a judge to basically strip a parent of their custody rights before they've even had a chance to speak in court is a huge deal.
It is an astronomical deal. It's called ex parte relief.
Ex parte.
Right. Ex parte means a judge issues a ruling based only on your side of the story without the other parent even being notified or present.
Wow. Courts must hate doing that.
Courts absolutely despise doing this because it completely bypasses that procedural due process we talked about earlier. To get an ex parte order in Broward County, you have to swear under oath that a true emergency exists.
Let me guess. The court's definition of a true emergency and a terrified parent's definition are very, very different things.
Worlds apart. The administrative order strictly defines a true emergency as one of two things.
Just two.
Just two. A, the child is currently threatened with physical harm, or B, the child is about to be improperly removed from the state of Florida. That's it. That is the entire list.
Wait, so if I find out the new partner is doing hard drugs in the bathroom, but nobody is physically hitting my child, that isn't considered an emergency?
Under the strict reading of the administrative order, general disagreements about the environment or discovering someone has a bad background explicitly do not qualify for drop everything ex parte emergency relief.
That's crazy.
Unless you can articulate an imminent threat of actual physical harm. The court's logic is that the system would just grind to a halt if every bad parenting environment was treated as a midnight emergency.
I mean, that has to be an agonizing reality check for a parent, to be told that their panic is completely valid, but it isn't legally an emergency. What happens if a parent files anyway, just hoping a sympathetic judge will intervene?
It can backfire catastrophically.
Fully.
Oh, yeah. The administrative order is very clear. If the court feels you are abusing the emergency process, you can face severe sanctions. The judge can order you to pay your ex's attorney fees, or they could even hold you in contempt of court.
Wow. So what are you supposed to do if your kid is in actual physical danger right now?
If actual abuse, abandonment, or neglect is actively occurring, your first call isn't to a family lawyer to draft a motion. Florida law mandates that you call the Department of Children and Families Abuse Hotline immediately. Right. That number is 1-800-962-2873. DCF has the statutory authority to investigate emergencies in real time in a way a family court judge sitting in chambers simply cannot.
Okay, but what if you were in that agonizing middle ground? Like, it's not a drop-everything DCF emergency, nobody is being physically hit, but you have concrete proof this third party is bringing dangerous instability drugs, verbal abuse, just chaos into the home. What is the legal path forward if you can't use the emergency trap?
The proper path is to file a supplemental petition to modify the existing parenting plan under Florida Statute Section 61.13, subsection 2C. And there is some incredibly good news here, actually.
Oh, good news is rare in family court. Let's hear it.
On July 1st, 2023, the Florida legislature passed House Bill 1301, which fundamentally changed how parents achieve this.
How so? What was the problem with the old law?
Under the old law, to modify a parenting plan, you had to prove three things: that a substantial, material, and unanticipated change in circumstances had occurred.
Unanticipated?
Yes, that word unanticipated was a total nightmare.
Why? I mean, it sounds straightforward.
Think about the mechanics of it. Let's say your ex had a long history of dating toxic, unstable people during your marriage.
Okay.
After the divorce, they move in with a new, incredibly dangerous partner. You go to court to modify the plan. Under the old law, your ex's lawyer would stand up and say, "Your Honor, my client has always dated toxic people. The other parent knew this. Therefore, this isn't an unanticipated change. They should have seen this coming."
You're joking.
I'm not. And judges were legally bound by that logic to deny the modification.
That is absurd. The law essentially forced parents to predict the future, or it punished the child because a parent had a consistent history of bad behavior.
Exactly. It created this totally illogical hurdle that left children at risk.
Right.
Recognizing this, the legislature enacted HB 1301 and completely stripped the word unanticipated from the statute.
Oh, it's huge.
It is. Today, you only need to prove two things: that there is a substantial and material change in circumstances, and that modifying the plan to restrict this third party is in the child's best interests. It doesn't matter if you saw it coming. It only matters that it is a massive problem right now.
So how does a judge evaluate that new standard? Let's look at some actual case law to ground this. How are appellate courts in Florida ruling when a parent tries to restrict time sharing because of a dangerous environment?
So a foundational case to understand the baseline is the 2021 Florida Supreme Court case, CNVIGC.
Okay.
Even though it was decided under the old standard, it permanently cemented the rule that the best interests of the child are absolutely paramount, and that any modification restricting a parent requires concrete, documented evidence, not just speculation about what a third party might do.
Right. Going back to the need for police reports and DCF records, not just bad vibes.
Precisely. But a more recent, highly illustrative case is Fernandez v. Gonzalez out of the 3rd District Court of Appeal. This really shows the new reality in action.
What happened in Fernandez?
In Fernandez, the mother petitioned to modify timesharing, and she won.
Awesome.
She succeeded because she didn't just complain. She presented a documented pattern. She provided evidence of the father's profound instability, his history of violent outbursts in the home, and how this environment resulted in an ongoing failure to meet the child's basic needs.
So it wasn't just like one bad weekend.
No, it was a clear pattern of behavior that demonstrably affected the child's welfare. The appellate court affirmed the modification, illustrating that if you can show a third party is bringing violent outbursts or deep instability into the home, and your co-parent is failing to shield the child from that chaos, the court has the authority to step in and restructure the time sharing to protect the child.
What about the decision-making power? Because in Florida, most parents have shared parental responsibility, right? Where they have to agree on doctors, schools, all the big stuff.
Yes, that's the default.
If my ex is exhibiting terrible judgment by keeping a violent person around, do I still have to share major decisions with them?
You might not have to. Under Section 61.13, subsection 2C2, while the default is shared parental responsibility, a court can restrict or even revoke that if it finds that sharing responsibility would be detrimental to the child.
Detrimental, that is a heavy legal word.
It is. If there is documented evidence of domestic violence, abuse, or neglect, even if the third party is the one doing it, but your co-parent is just allowing it to happen, the court can determine that forcing you to co-parent and make joint decisions with someone who has such compromised judgment creates a detriment to the child.
Wow, okay.
Yeah, and the court can grant you ultimate decision-making authority over certain aspects of the child's life.
So, bringing all of this together, if you are the parent listening to this, trying to figure out your next move in Broward County, here's your framework. The court cannot directly ban a dangerous roommate or a new partner.
Right, you can't bind a ghost.
Exactly, you can't bind a ghost. But the court has vast power to restrict your co-parent's time sharing if they bring that person around. To trigger that power, you cannot rely on an emergency motion unless there is imminent physical harm or a threat of fleeing the state.
The physical harm standard is strict.
So strict. Otherwise, you modify the parenting plan. And to win that, you need a mountain of concrete evidence. DCF records, police reports, a 61.27 social investigation proving that your co-parent's present judgment is fundamentally failing the best interest factors.
That is an excellent summary. And because the procedural rules, particularly Administrative Order 2019-99 UFC and the 17th Circuit, are incredibly unforgiving and the deadlines can be brutally short once a motion is filed, consulting a licensed family law professional in Broward County isn't just a suggestion, really.
It's a must.
It's practically a necessity. Do not try to navigate the emergency motion trap or a complex modification trial alone.
As we wrap up this deep dive, I want to leave you with a final provocative thought to really mull over. Let's say you do everything right. You hire the lawyer, you gather the police reports, you survive the hearings, and the judge signs an order.
A huge victory.
A huge victory. The order says your co-parent is strictly prohibited from having this dangerous person around your child. You won. But remember our opening scenario.
Yes. An order from a judge is ultimately just a piece of paper. It does not create a magical force field around the house.
Exactly. So the lingering, maddening question is this. How does a parent effectively monitor and enforce a third-party restriction inside someone else's private home?
It's incredibly difficult.
If you constantly interrogate your child about who was at the house, or if you drive past your ex's house looking for the new partner's car, you risk crossing the line into harassment. You might even face accusations of parental alienation for grilling your child.
Which is a whole other legal mess.
It is a terrifying psychological and logistical tightrope. The law creates the boundary, but it leaves you, the parent, entirely alone to walk that tightrope. Good luck out there.
This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.